That's what is purported. And that's why, as a lawyer and officers of the court, we should give fidelity to the Constitution. If even these matters were acceptable to be put in the public domain, custody issues will come up. Where is she getting it from? Evidence and custody. Where is she getting it from?
She had actually said that leakage of the petition by some government officials. It was one of the questions I was going to ask her to show which government official she's referring to. And my viewers and listeners, this is what I do. Once you make allegation, I hold you to prove the allegation. And sometimes, you know, the partisanship of how you view the things, you say, why are you doing this? But I have to do it. Even if I have seen one, I still need the person to prove them. Okay, so yes.
So for me, we can continue talking about what this conversation is about. But my position is that there's good reason why Article 146 is in our Constitution. It is to ensure judicial accountability. And there's also good reason why you need a judicial tribunal as advised in the 1969 Constitution, which in the 1992 Constitution is a tribunal to determine whether there's a prima facie case. I mean, why you need a Council of State acting in consultation with the President to determine a prima facie case, and you need a judicial tribunal to subject the person, the respondent, to trial. And the respondent must be given all opportunity under Article 146 to defend himself or herself. So the fidelity of the process is what we should be concerned with. Whether the rights, and I see a lot of rights, I also see a lot of constitutionalism embedded in Article 146. I mean, any day I look at the Constitution, Article 146, I say, wow, the design appears to be perfect, even though we've been criticizing the Constitution. First of all, the whole Article 146 is not about the Chief Justice. It's about the removal of justices of the Superior Court of Judicature and regional tribunal, because the regional tribunals are part of the Superior Court of Judicature. Now, look at how the Constitution proceeds. If the matter concerns a judge of the Superior Court of Judicature, what is the role of the President?
Zero. Postmaster, conveyor belt.
Zero.
Receive the petition and give it to the Chief Justice.
The Constitution doesn't say that the Chief Justice is to determine whether the petition, the Constitution doesn't say that the Chief Justice is to determine whether the petition raises a prima facie case with the Judicial Council.
It's a sole job.
It's a sole job.
Absolutely.
It's a sole job. Now, but the Chief Justice is a justice of the Superior Court of Judicature. So, and again, head of the judiciary. When a petition is against her, you can't send the petition to the Chief Justice to determine whether a prima facie case has been made against her. Naturally, it will raise the concept of natural justice, being a judge in her own cause. What does the Constitution do? The Constitution imposes an institutional limitation on the exercise of the power of the President. Because Article 58 of the Constitution vests exclusive executive authority in the President. It says the President cannot do it alone. He cannot determine whether the petition raises a prima facie case. He must do it in consultation with the Council of State. And if adherence is to be a guide, the Taba says the Council of State must play a prominent role in the decision. So as constitutional lawyers, what do? We want to see that the process is followed. Why is it so? So that to protect the Chief Justice against a capricious and vindictive executive. That's why it is so. That's why that limitation is on the exercise of that power. Now, so even though and I agree entirely with the reasoning in Ajechu, even though Article 1466 does not include prima facie, but it stands to reason that because the Chief Justice is a justice of the Superior Court of Judicature, you probably will flout on Article 17 of the Constitution if you do not establish in her case a prima facie case. And so, apart from the reasons given by Databa in the Ajechum case, you can't treat people differently equally circumstanced differently. So, the prima facie case is determined. And when the prima facie case is determined, again, there is a procedural limitation on the exercise of power of the president. Article 46(10). That decision to suspend must be in accordance.
I understand by my production that we have Diana back. Hopefully, we can do this very quick because it's getting unnecessarily prolonged because of the hitches that we're having.